Enrico Milano est professeur à l'université de Vérone et il est aussi j'ai écrit en anglais, donc Legal Advisor of the Permanent Mission of Italy to the United Nations in New York. Donc on va passer à la question de la différence de point de vue en droit international entre notamment l'enseignant-chercheur et le politique.
Monsieur et Madame la Présidente, buenos días a todas y a todos. Quisiera agradecer a la Sociedad Peruana de Derecho Internacional por la acogida y la invitación, y aussi la Société française de droit international por la invitación, e chiaramente anche la Società italiana di diritto internazionale. First of all, I should say I didn't have the fortune of meeting Professor Sorel in front of the Casa della Letteratura Peruana yesterday. I arrived too late to have that fortune. So I have to stick to my plans that was agreed with the organizers to speak, and I will speak in English. I also have to say at the very beginning that the topic that has been assigned to me is to deal with the discourse of states about international law. And of course I have the fortune and privilege of working at the United Nations as a legal advisor for the mission of Italy. So I live and I see and I participate in the discourse of states on international law on a daily basis. But today that fortune is double, and it has to do with the fact that I'm talking in a personal capacity, not in an official capacity, so I will have a bit more freedom than I usually have in what I'm going to say. The organizers have entrusted me a very limited time to deal with a very broad and vast topic, the discourse of states over international law. But I take literally what is in the draft concept of the conference when it is said the speakers, and I'm quoting, are not expected to deal in depth, but only to provide an overview and stimulate the debate. I will try most of the latter to stimulate the debate. How do I want to proceed to deal with the topic that has been entrusted to me? I gave some thought how I would spend my 8 minutes, and of course what came to my mind that we had a very good opportunity to look at and to analyze the way states speak and use the language of international recently in the Security Council in the month of January. On the 12th of January this year, the Japanese presidency organized a very timely open debate to which all member states were invited to participate over the relevance of the rule of law in matters of peace and security, and more broadly in matters in international affairs. The record of the meeting is a very interesting document. It's a very long document. It has been a long debate. More than 75 delegations have participated, with more than 100 member states expressing their positions. There are more than 80 pages of records of the meeting, but I would recommend the reading to anyone who is interested in this subject, because it really provides, I think, a rather accurate picture of the conceptual and linguistic and epistemological toolbox on how states use and speak the language of international law, which of course still remains a common language, a language that unites states, that unites societies, that unites regions of the world. But also, if you study, examine, and you look at those 80 pages, you can identify some important fault lines. And these are the fault lines that I think characterize international law nowadays, and I think we must recognize them, we must look at them and think in ways in which we can transform those fault lines in common ground. And I think occasions like this, meetings of national and regional societies of international law, are very important opportunities in this respect. So I have identified 3 major fault lines, systemic or conceptual fault lines, which characterize the language of states with regard to international law and how they employ it in a multilateral system like the United Nations. There is a 4th one, which I think is a bit more hidden in the debate, but on the basis also of my daily experience, I think it is there. It pops up in the debate here and there, but I will get back to that in a minute. So the first fault line concerns the language which is often employed, especially by Western states and Eastern European states, of the concept of rules-based international order. Now, if you look at many of the statements that use the language of the so-called rules-based international order, you see that international law is considered at the center at the rules-based of international order, as much as the rule of law is considered at the center. So that already raises the question whether rules-based international order and international are the same thing. And probably the answer is that they're not. Because of course, in the concept of rules-based international order, an important place, a central place, is there for international law, but also broader normative assertions, normative frameworks. There are also broader issues and concepts of accountability, broader assertions on the relevance of democracy and human rights in domestic legal systems, or the rule of law in domestic legal systems. Now, it is interesting that this fault line comes and manifests itself in the statements of certain delegations. I mentioned, for the sake of time only, the statement by China, which was very vocal on this issue. The Chinese delegate refers to the concept of rules-based international order as something, and I quote here, ambiguous, and again I quote, not found in the Charter or any other intergovernmental document, agreed intergovernmental document. Of course, you find this also in other statements. I'm not telling you that it's only Western European states that use the language of rules-based international order. You see it in, I must say, it's a minority of cases, in more limited cases. You also see it coming up in certain statements of Asian countries, in certain statements of Latin American countries, but certainly is a common language put forward by Western delegation and European countries. The second fault line has to do with peaceful settlement of disputes. Now, of course, when you look at the relevance of the rule of law in international affairs, the peaceful settlement of international disputes has a central role. This is not at all a new discussion, a discussion that dates back to the beginning of the 20th century, if you like, also to the Hague Peace Conference of 1899 and 1907. Namely, the idea that in order to reinforce and promote the rule of law in international affairs, disputes have to be adjudicated through compulsory mechanisms, whereby courts and tribunals should be endowed with the power to issue awards, to issue judgments that are binding for the parties to the dispute. Now here, again, if you look at some of the statements that, again, here I mention because it's more articulate in that and it's more vocal in that, I want to point to the Chinese statement. Here, the peaceful settlement dispute is not so much about the compulsory dispute settlement, it's about the use of diplomatic means of dispute settlement. It's about negotiation, it's about consultation, it's about mediation, it's about good faith. And notice that the same kind of conversation is the kind of conversation that we've had very recently in the negotiations over the BBNJ High Seas Agreement, where you have interesting clauses on dispute settlement, including compulsory dispute settlement, and advisory opinion by ITLOS, which were hardly and toughly negotiated with especially China, but not only China, I think also some Western countries like Australia and the UK, asking for carve-out exceptions, for exceptions related to issues where you'd have claims, even unilateral claims, to maritime areas or to land features like islands. Now, the good news with regard to the BBNJ agreement that we found a common ground at the end. There was some consensus. I mean, some academics, some international lawyers may not like those provisions, but I think the fault line is there, but in that case, a common ground was found. A third point is the narrative on selectivity and double standards. This is something you find in many statements. It's not only in the statements, as you could imagine, of the Russian Federation or of China, where probably the argument is more articulated, but you have the argument, the point on double standard and selectivity used in many statements of African countries, for instance. Also in some cases in statements made by Latin American countries. Now, what is interesting for me is that the fault line is there. It hasn't been properly addressed, but if there has been one Western delegation that has mentioned it, his guess is the US delegation, Ambassador Thomas Greenfield. It's, at one point of her statement, she said, and she seemed to respond to the argument of double standards, and I quote, "We have not been perfect in the past, but now we are holding ourselves to a higher standard." Obviously, this is an assertion that is trying to respond to the argument of selectivity and double standard that is there and represent, I think, a fault line in the way we address and we use as states international law. There is a fourth one which has to do with codification, progressive development, something that interestingly was received little attention in the open debate at the Security Council. It was mentioned also, I must say, by my own country, Argentina, Ecuador, Kenya, and China. China, in order to reaffirm what they consider the Grundnorm of consensus in international lawmaking. But quite interesting, it was not, it had little attention, and even if it has not escaped my attention, but I think the BBNJ negotiations, which were at that time in a final stage, were not even mentioned once. So this is really some food for thought on the basis of this important occasion that we had recently at the UN. Of course, here we are talking about conceptual and legal fault lines. It's not a geological fault line that necessarily has to produce sooner or later an earthquake. I think we are all here as academics, as legal practitioners, to find some common ground and transform really those fault lines in an occasion to find a consensus and a common language. Thank you so much.